For sure. Good morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court Law Number 2. This morning, we have two dockets. We have an announcement docket and a motion to revoke probation docket. When I call your name, please come before the bench with your attorney. If your attorney is not here, we'll wait for your attorney to arrive, because your attorney may be in another court handling another matter. If you are not represented by an attorney, when I call your name, please come before the bench by yourself. First case is cause number 23CCCR 0730. Case is style of State of Texas versus Lisa Ann Norris. On our motion to revoke probation docket. Okay, this is cause number 23CCCR 0730. Case is style of State of Texas versus Lisa Ann Norris. Ms. Norris, is that your full name? Yes. How are you doing, Ms. Norris? That's good. Now, Ms. Norris, the state is represented in this case by Attorney Haley Simmons. Ms. Simmons, how are you doing? I'm doing fine, thanks for asking. And the probation office is represented, or in this case, by Mr. Gary Gilliam. Mr. Gilliam, how are you doing?
Fine, thanks.
And Ms. Haley Simmons and Mr. Gilliam, what is
Our recommendation is revoked.
okay, now let's do this here. Okay. Okay, Ms. Norris. I have before me a document that is titled Motion to Revoke Probation. This motion was filed by the Jefferson County District Attorney's Office. Let's see, motion. In this motion, it alleges that you, Lisa Ann Norris, was tried in County Court at Law Number 2 of Jefferson County, Texas on August 15th, 2023 for the offense of theft. The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt. However, the court deferred adjudication of guilt and placed you on unadjudicated probation for a period of 12 months. In this motion, there are 5 allegations. Allegation number 1 alleges that you, Lisa Ann Norris, failed to pay court-assessed fees as ordered by the court, and as of November 21st of 2023, you were $405 in arrears in violation of condition number 9 of your probation order. Allegation number 2 alleges that you, Lisa Ann Norris, failed to immediately report to the probation officer your address, your change of employment as ordered by the court in violation of condition 13 of your probation order. Allegation number 3 alleges that you failed to perform community service hours as required by the court in violation of condition 17 of your probation order. Allegation number 4 alleges that you, Lisa Ann Norris, failed to complete a theft prevention program as ordered by the court in violation of condition A of your probation order. And allegation number 5 alleges that you, Lisa Ann Norris, failed to report to Jefferson County Probation Office each month by web or mail as ordered by the court in violation of the special amendment dated August 2023 of your probation order. Now, Ms. Norris, if the court finds that any one of these allegations are true, your probation can be revoked. And if your probation is revoked, you could be assessed jail time up to 1 year, which is 365 days, because this is a Class A misdemeanor.
Yes, sir.
Do you understand?
Yes, sir.
Ms. Mosby, could you give her some paperwork? Hold on a minute. She's going to give you some paperwork I need to go over with you.
Yes, sir.
Okay, now, Ms. Norris, as a defendant in a criminal case, you have a right to have an attorney to represent you. The documents that you have been handed, the first document is titled Judge's Explanation of Rights to Defendants Without Attorney. That document looks like this. Okay, I'm going to go over this document with you.
Yes.
Now, as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, to represent you, and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. If you want an attorney but do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, on that clipboard, the financial questionnaire is a 3-page document that's titled Jefferson County Affidavit of Interest, and it looks like this. Okay, now if you want an attorney to appoint it, you'd have to fill out the first page of this document, and on the second page, you will fill out the top portion that is titled Defendant's Oath. And then you will come down and fill out the middle portion that is titled Unsworn Declaration by a Defendant. Do you understand?
Yeah.
All right. Now, let's go back to that first document, Judge's Explanation. Now, the next paragraph states that you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to have an attorney. Now, that's for individuals who will be waiving their right to an attorney, giving up their right to the attorney, they would like to represent themselves, they would have to first sign a written waiver. The written waiver is another document on that clipboard that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You would, if you are representing yourself, if you're designed to represent yourself, you will sign that document. If you want to hire an attorney or if you want to apply for a court-appointed attorney, you do not have to sign that document. You understand?
Yes.
Okay. Now, go back to that first document, judge's explanation, second to the last paragraph, and it's in block letters. It's at the second to the last above where it says Judge Terrence L. Holmes, where the judge signed at the bottom. Okay, you see that there's two. The second to the last paragraph, it starts off by saying, be aware. You see that?
Yes, sir.
It said, be aware. Now, this is for people who would like to represent themselves. It says, be aware there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last paragraph states that if you choose to proceed without an attorney, you may change your mind at any time and you may request that an attorney be appointed to represent you. Do you understand that?
Yes, sir.
All right, now at the bottom of this document, in bold letters, it states defendant's choice, mark initials next to only one choice. Now, if your choice is to hire your own attorney, you'll place your initials on the first line to the left. Now, if your choice is to apply for a court-appointed attorney, you'll place your initials on the third line to the left. If you would like to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of those lines to the left, you will sign your name on the line that is titled defendant, and you will date it today's date, May 7th of 2025. Do you understand?
Yes, sir.
Now, on that first document, okay. Let's see. Okay. Okay, so you want to apply for a court-appointed attorney? You have that clipboard, you have a pen, you can take a seat, fill out that document. Once you finish filling out that document, we're gonna call you back up.
Yes.
You want more, please?
Yeah, hold on a minute.
Yes, sir.
All right. Okay. Thing up here. Okay. Mr. Paget, is that Virgil Trahan?
Yes, Your Honor, he's on Zoom this morning, and it's Mr. Hubel's case.
Okay, we have cause numbers 25 CCCR 0238, cause number 25 CCCR 0248. Both cases style the state of Texas. They have Virgil D. Trahana Jr.
It's Trahan, Your Honor, Trahan.
Okay, but they have an A at the end of.
I do understand that. I ran into that little issue, Your Honor.
Okay. And Mr. Trahan, you can take your mic off of mute.
Yes, sir.
How are you doing, Mr. Trahan?
Fine, you, sir.
I'm doing fine. Thanks for asking. Now, Mr. Trahan, you're represented in your case by your attorney, James Paget. Mr. Paget, how are you doing?
Doing well. Good morning, Your Honor.
Good morning. State is represented in these cases by attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge. Thank you.
You're welcome. Mr. Paget, what is your announcement in these cases?
Your Honor, I've reviewed everything but the video evidence, and as soon as that comes in, I'll discuss it with my client. I've also taken the time to get an offer from Mr. Hubel. So at this time, I'm not prepared to accept the offer until I review that videotape. But everything
Give-
else I do have access to.
Give us a reset.
Sounds good to me.
Okay, these cases will be reset to June 23rd, 2025. Mr. Trahan, your attorney and your bondsman will be given notice of your recess. Hold on. I have bond. Hold on a minute. That's true. The first one is 38. Okay. Richmond some bond conditions. Now, Mr. Trahan, I'm going to give you some bond conditions. Your attorney will be given a copy of these bond conditions. And you can get the copy from your attorney. And basically, these are standard bond conditions in County Court at Law number 2. And it states, following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bill bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply. Condition number 4 does not apply because this is not a DWI second. Condition number 5 does apply. It says defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay. Now, Mr. Trahan, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. Now, these conditions, these bond conditions, we'll give a copy to your attorney. He can provide a copy to you. Okay? And
Yes, sir.
your cases are reset till June 23rd, 2023. Stay in contact with your attorney and your bondsman. You're free to go. And you have a blessed day.
You too, sir. Thank you.
Thank you. And Mr. Paget, I think this is your only 2 cases?
Yes, Your Honor.
Okay, you can get your reset in these bond conditions and you'll be free to go.
Oh, thank you, Your Honor.
Okay,
Have a good day.
all right, same to you. Here you go. That's it. We have Billy Nutt. Oh, yeah. It was, see what happened?
I don't know, I sent it to you.
I don't see it anymore. It was here. Oh, there it is.
You're right.
Oh, it's- yeah. That's how it is. Oh. Jefferson County Court of Law number 2 is in session and calls number 25 CCCR 0028. Cases style of state of Texas versus Billy Travis Nutt. Mr. Nutt, is that your full name?
Yes, sir.
Mr. Nutt, would you please raise your right hand? Mr. Nutt, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Nutt, you may put your hand down. How are you doing, Mr. Nutt? I'm doing fine, thanks for asking. Mr. Nutt, you're represented in your case by your attorney, Willard Hall. Attorney Hall, how are you doing?
I'm doing great.
Mr. Hall, do you waive a record in Mr. Nutt's case?
Yes, we do.
Mr. Nutt, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Billy Travis Nutt, on or about August 16 of 2024, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed to Class A misdemeanor offense to driving while intoxicated. Second state, are you abandoning the enhancement paragraph?
That's correct, Your Honor.
Mr. Nutt, the state is abandoning the enhancement paragraph. And what that basically means is instead of being charged with a Class A misdemeanor DWI, you'll be charged with a lesser included offense, which is a Class B misdemeanor offense DWI. Do you understand that? Now, to the Class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about August 16 of 2024, while you were operating a motor vehicle in a public place in Jefferson County, Texas, how did you plead guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
Yes.
Mr. Nutt, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
Okay. On page 2 of this same document, there's a set of initials on a line next to a box that says check guilty. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that is checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a, where's the discovery reserve?
Yeah.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Mr. Nutt, before you signed and initialed these documents that I just showed you, did your attorney go over these documents with you? Did you understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Nutt, are you a citizen of the United States?
Denver 6-1.
Any objections?
No objection.
No objection. States Exhibit Number 1 will be admitted. Mr. Hall, you have advised and counseled Mr. Nutt Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Nutt, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Nutt, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 90 days probated of 1 year with a $500 fine, 40 hours community service, the installation of a statement interlock device, and DWI standard conditions of probation.
What is the court cost? Okay. Mr. Nutt, the state is offering that you serve 90 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. You will also be required during the 1 year probationary period to pay a fine of $500 plus court costs of $392. You'll be required to pay a DWI conviction fine or fee of $100. You'll be required to pay a probation fee of $6 a month. You're now pay $15 a month. Reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $173 a month. Will you be able to pay the $173 a month? You'll also be required to perform 40 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete the DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of probation. Mr. Nutt, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Good, Mr. Nutt, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Nutt, you will stand next to the bailiff, follow her directions at the end of that counter. And once you finish following her direction, you'll be free to go. And you have a blessed day.
Thanks, Toby.
Yeah.
Austin Ratley,
Yeah.
Austin.
He could-
okay. This is cause number 25 CCCR 0552, case of style of state of Texas versus Austin Caleb Ratley. Mr. Ratley, is that your full name? How you doing, Mr. Ratley? That's good. Now, Mr. Ratley, you're represented in your case by your attorney, Alan Parker. Attorney Parker, how are you doing?
Good, Judge, thanks.
You're welcome. And the state is represented in this case by attorney Haley Simmons. Simmons, how are you? Okay. Now, Mr. Parker, what is your announcing in Mr. Radley's case?
We got a plea deal worked out. We just like to reset it one more time, and put it on the plea docket so we can take care of a few things.
Okay, give us a reset.
Is that a Wednesday, 19th? Please.
June 25th.
Okay, this case will be reset to June 25th of 2025. Mr. Radley, you get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day.
Thank you,
And
Judge.
Mr. Parker, you're free to go as well and you have a blessed day.
You send it.
You have a, oh, okay, this is cause number M321225. Case of style of state of Texas versus Russell Thomas Bean. Russell Bean was scheduled to be in court this morning at 9 a.m. at or about 9 a.m. The bailiff called Russell Bean's name at the courthouse door. Russell Bean did not answer. Russell Bean has not appeared in court since the court has been in session. The time now is 9:43 a.m. on today's date of May 7 of 2025. Ms. Bailiff, would you please call the name of Russell Bean at the courthouse door? Okay. Russell Bean's name was just called to get at the courthouse door. Russell Bean did not answer. A reasonable time has passed to give Mr. Bean an opportunity to appear in court. He is not appearing in court. State, do you have a motion?
Say, Mr. Bond Forfeiture.
That motion will be granted. Russell Bean's bond will be forfeited and a warrant shall be issued for his arrest in cause number M321225. And Mr. Cole, you're free to go.
Thank you.
Oh. Oh, oh. Okay.
Bring him up there.
Yeah, I didn't understand it.
Thank you.
Yesterday. Yeah, I texted, I talked to you yesterday. I see, Judge.
Yeah, hold on a minute. Yeah, he's on the MTRP docket. Who said he was in jail? Did he just get arrested today or something? He might be he might be in the holding cell. If it does he have a felony?
I don't see it. I don't see it. What'd you say?
We're gonna check and see if we have, that's it? Well,
Is Mr. Grove taking it to somebody else?
Possibly, I spoke to him yesterday.
talk to who? Bean?
Mr. Bain.
Wow.
So something happened between.
Yeah, yesterday and today. Don't know what. Yeah. Let's see, got.
This is the only guy who came from this county, unless he thinks he's in another county.
Well, he said he talked to him yesterday.
No, I know. I'm wondering if Mr. Grove is they could give it to someone else.
Yeah, he might be. Yeah, okay. Yeah, you're free to go. Let's see, we got Mr. Aaron Wars. Okay, this is cause number 24 CCCR 2840, case of style of state of Texas versus Aaron Michael Wars. Mr. Wars, is that your full name? How are you doing, Mr. Wars?
Okay, man.
That's good. Mr. Wars, You're representing your case by your attorney, James Macon. Attorney Macon, how are you doing?
I'm doing wonderful, Your Honor. Thank you.
That's good. Mr. Macon, what is your announcement in Mr. Ward's case?
Your Honor, Mr. Wars has another case that has not been filed yet, and I'm waiting on that to get filed before I work out a plea on everything he has. So I asked for a short reset.
Is it,
It's part of the same criminal episode. Your Honor.
but is it, do y'all have the case or
We don't have it yet.
the agency still have it?
Not yet, we don't, Your Honor.
Okay, give us a reset date. Okay, this case is reset to June 23rd, 2025. Now, Mr. Wars, before you get your reset, I need to give you some bond conditions. Document that I have before me is titled Standard Bond Conditions in County Court at Law Number 2. And it states following return of a criminal information in County Court at Law Number 2. All bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. You understand the condition?
Yes, Your Honor.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Condition number 3 does not apply, and condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? And now, Mr. Ward, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be placed in the Jefferson County Jail. You can get a copy of your bond conditions and your reset from our coordinator. Once you get a copy of your reset and your bond condition, you're free to go and you have a blessed day. And Mr. Macon, this is your only case?
That's the only one.
You're free to go as well and you have a blessed day. Anybody else?
Thank you, Your Honor.
Okay, you're welcome. Lisa Ann Norris. Okay. Ms. Norris. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. And the second document is titled Jefferson County Affidavit of Indigence. Now, the judge's explanation. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes,
And are these your initials on the line that state you'd like to apply for court
Yes.
appointed attorney? The next document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
yes, sir, it is.
Now, Ms. Norris, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Ms. Norris, I read your answers. Based on your answers, you meet the eligibility requirements. It was from yesterday. You meet the eligibility requirements. Did she, Was that the lady, yesterday, she changed my, okay, we could show that. Okay, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you. He did? Oh,
Yes.
okay. That's Mr. Matuska. You can probably, if you want, if he wants to meet with you, he can meet with you, today.
Okay.
Okay, but that's your attorney.
Yeah.
Okay, now I'm going to. Your case, give her a reset date,
Okay. Thank you.
June 25th.
Yes.
Okay. So your case will be reset to June 25th at 9 a.m. You're gonna get a copy of the reset. Once you get a copy of your reset, you'll be free to go. And if you'd like to talk to Mr. Matuska, he should be right outside the door.
Yeah.
Okay, stand in front of the court coordinator. And Mr. Gillum, yeah, you're free to go and you have a blessed day.
Thank you, sir.
Okay. We don't have nobody else ready, Mr. huh?
Okay.
Mr. Johns. You ready on your case? Okay, Landon Paye. Good morning, Mr. Johns. How you doing? Okay, now this is cause number 24 CCCR 2756. Case of style of state of Texas versus Landon Paye. Ms. Paye, is that your full name? Okay, how are you doing, Mr. Paye? That's good. Mr. Paye, you're represented in your case by your attorney, Theodore Johns Jr. And again, Mr. Johns, how are you doing?
Pretty good, you know.
Okay, Mr. Johns, what's your announcement in Mr. Paye's case?
Well, I'm gonna ask for a 30-day reset notice. We knew coming in here today that there was a pending felony case. We hadn't gotten word of. The district attorney just showed me where I guess they've been indicted. He's found
Yeah.
that.
Not yet. I just have a newly received assault.
Okay.
Nothing's been filed as of yet.
So what I want to do is,
So there's a possibility that
There's gonna be.
felony is gonna be filed? It's a misdemeanor?
the misdemeanor. Well,
Hold on a minute. They can see it, we can't.
yes, sir.
Yeah, it's just a misdemeanor right now from what I see. I don't know if anything's gonna change.
Do y'all have it in y'all possession or is it still with the agency? Do you know?
It's just received, Your Honor.
Oh, so they have it.
At this point, nothing's been filed.
Okay.
Can I get a case number on
They don't have a case number. It's not been filed.
that? On the assault? Okay,
Yeah, just the DA's office received it from the
yes, sir.
police department. Okay, so we need to reset it.
Yes,
So we have an unfiled misdemeanor.
Yes, Your Honor.
That's a new unfiled misdemeanor. Okay, give us a reset date. Yes, yeah, because there's a new case that's possibly be coming down the pipe.
23rd or 25th.
Which one is for you?
Let's do the 23rd.
Okay. Okay, this case will be reset to June 23rd, 2025 at 9 a.m.
Yes, sir.
So you're gonna get your reset from June 23rd.
We don't get a piece of paper.
Okay, yeah, you're gonna get your reset for June 23rd, 2025 at 9 a.m. Once you get your reset from our court coordinator, you're free to go. You have a blessed day. Mr. Jones, this you on the case?
Yes, sir.
You're free to go as well, and you have a blessed day.
Can I have you sit out there while I get the resets?
Okay, that's fine. You can just have a seat. All right. See, he got his parents with him. His parent is, okay. How you doing? Okay, what else we have? Court is back in session and calls numbers 25 CCCR 0262 and calls number 25 CCCR 0263. Both cases are styled the state of Texas versus Norris Gallo. Mr. Gallo, is that your full name?
Yes, sir.
How are you doing, Mr. Gallo?
Bless.
That's good. Cannot be better than being blessed. Now, Mr. Gallo, I see here, you have a pending felony, is that correct?
Right, correct. That's,
It's the same offense date.
right.
Okay, so your felony is set What? on the 23rd of June? Okay, so we need this is not the same criminal episode, so we can set these on the same date. State, you have any objections?
None at all, Your Honor.
So, Mr. Gallo, these cases will be reset to June 23rd, 2025 at 9 a.m. On that date to appear this court first, check in with the bailiff, and then go to the felony case. And once you're finished in the felony case, you just come back here and let us know what happened.
Okay.
All right?
Yes,
You're gonna get your reset. Once you get your reset, you'll be free to go stay in contact with your boss.
yes.
Okay? Stand in front of the court coordinator.
He can have a.
Have a seat.
It's
Yes.
gonna be, it's gonna be June 11th. We will keep it on the interactive.
June 11th.
Yeah.
Okay, that's the date. Okay,
Yes, this one.
June 11th.
Just have a seat.
Okay.
Uh-huh.
Okay. No, not you. She was talking about another case. Joshua King, Mr. King is appearing on Zoom. Mr. King, you can take your mic off of mute.
Yes, sir.
Good, Mr. King.
How you doing? Good morning, Judge.
Okay, good morning. Now, Mr. King, your case was, well, this is cause number 24 CCCR 1960. Your case was reset from March 18th, 2025. To give you an opportunity to hire an attorney. Have you hired your attorney?
No, sir. I wasn't able to due to the fact of my father passing, so I might either take a court appointed or I need an extension on that.
Okay, well, you're gonna need to, in order to qualify for court appointed attorney, you'd have to appear in court and
Yes, sir.
fill out the necessary paperwork. Okay?
Yes, sir.
We're gonna reset your case.
Yes, sir.
Give us a reset date. Okay, this case will be reset to June 25th. And at 9 a.m., you need to be here in person. Also, Mr. King, you said that your father passed?
Yes, sir. That's why I wasn't able to appear in person. Yes, sir.
Okay, well, you and your family have my condolences.
Thank you.
All right. Again, your case is reset 9 a.m. on June 25th of 2025. You're free to go and you have a blessed day.
You too. Thank you, Judge.
You're welcome. Holly Perky?
Good morning.
Good morning. This is cause number 25 CCCR 0298. Case is styled of State of Texas versus Holly D. Perky. Ms. Perky, is that your full name? How are you doing, Ms. Perky? I'm doing fine, thanks for asking. Ms. Perky, would you please raise your right hand? Ms. Perky, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Perky, you may put your hand down. Ms. Perky, you're represented in your case by your attorney, Attorney Jack Lawrence. Mr. Lawrence, do you waive a record in Ms. Perky's case?
Yes, Your Honor.
Ms. Perky, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Perky, it alleges that you, Holly D. Perky, on or about April 21st of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated, which allegedly occurred on or about April 21st, 2024 in Jefferson County, Texas, while you were operating a motor vehicle in a public place. This information further alleged that prior to the commission of this offense on September 4th of 2019, in cause number E111410 in the county court at law number 2 of Orange County, Texas, that you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Ms. Perky, is that true? Now, to this charge of driving while intoxicated, second, how do you plead guilty, not guilty, or no contest?
No contest.
Now, you're pleading no contest freely and voluntarily?
Yeah.
And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Perky, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on the line next to boxes checked Nola Contendere, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? On the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Ms. Perky, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
She had a question, Your Honor, I think about the interlock.
Well,
Okay.
okay. So, let's see now. On the discovery certification, is this your signature on the line that's titled Defendant?
It is.
Now, again, Ms. Perky, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Ms. Perky, are you a citizen of the United States?
Terrence, there's one.
Any objections to State's Exhibit Number 1?
No objection, Your Honor.
Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Lawrence, you've advised and counseled Ms. Perky. Is there any evidence that she is currently mentally incompetent to stand trial?
None, Your Honor.
And Ms. Perky, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent representation?
Yes.
Ms. Perky, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Hey, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 180 days prorated over 2 years. Fine is to be waived. There is $4,850 of restitution to be payable to Barry Foster, $50 community service, DWI second standard conditions of probation with interlock and intervention. The 72 hours jail time defendant is to turn herself on June 27th at or before 6 p.m. This will be Friday, Your Honor. And the court cost, there is 2 days credited towards that court cost.
As to the final court cost.
The fine was waived in this, Your Honor. There was no
Okay.
restitution.
What is the restitution?
Hmm?
What is the restitution?
Didn't y'all waive the restitution?
No, what was
No,
the
we waived the
restitution?
fine.
Oh, okay.
Who's- I'm not sure.
I can.
So you need to talk to your attorney, you need to talk to your attorney about that?
Do you need to talk?
You need to talk to him. No, y'all can,
I'm fine, I just didn't know I had to pay probation.
do y'all need to talk?
The restitution?
Yeah, let me do this here. I'll just take a short recess. I'll just take a short recess so y'all can, discuss that, okay?
All right, thank you.
All right. Y'all can step outside if y'all need to talk. Yeah, step outside. Y'all can talk about it. Mr. Crowe, okay. I'm gonna send, Perky back to you. You can send it back to me. Miracle Ford,
Yes.
okay, this is cause number 25 CCCR 0186, case of style of state of Texas versus Miracle Montrell Ford. Ms. Ford, is that your full name? Ms. Ford, would you please raise your right hand? Ms. Ford, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Ms. Ford, you may put your hand down. How are you doing, Ms. Ford? I'm doing fine, thanks for asking. Ms. Ford, you're representing the case by your attorney David Grove. Attorney Grove, how are you doing?
Real good, Your Honor.
And Mr. Grove, do you waive a record in Ms. Ford's case?
Yes, sir.
Ms. Ford, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Miracle Montrell Ford, on or about December 11th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of failure to identify and giving false or fictitious information. Ms. Ford, do you understand what you've been charged with? And to this charge, Ms. Ford, how do you plead? Guilty, not guilty, or no contest? Now, you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges.
Yes, sir.
Ms. Ford, I also have before me a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that says check nola contendere, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a set of initials, well, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have before me a document that is titled discovery certification. Do you recognize this document? Is this your signature on the line that's titled defendant? Ms. Ford, before you signed and initialed these documents, did your attorney, Mr. Grove, go over these documents with you? Did you understand everything that Mr. Grove went over? And is everything in these documents true and correct to the best of your knowledge? Ms. Ford, are you a citizen of the United States?
State offer states one.
Any objections to State's Exhibit number 1?
No objection, Your Honor.
No objection, State's Exhibit number 1 will be admitted. Mr. Grove, you've advised and counseled Ms. Ford. Is there any evidence that she is currently mentally incompetent to stand trial?
None that I'm aware of.
And Ms. Ford, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation? Mr. Ford? Ms. Ford, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred probation, $250 fine, 30 hours community service and court costs.
Okay, Mr. Grove, were you appointed in this case?
Yes, Your Honor.
Yes, we did.
Okay. What's the court cost?
277.
Ms. Ford, state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $250. You'll also be required to pay court costs of $277. You'll be required to pay probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $163 a month. Are you able to pay the $163 each month? Okay. Give me her affidavit of indigence. Okay, Ms. Ford. I have before me a document that is titled Jefferson County Affidavit of Indigence. I'm going to hand this document to your attorney. And he's going to hand this document to you. Ms. Ford, do you recognize that document? On page 2 of that same document, there are a set of initials where there's a signature above the line that's titled defendant's signature, top left-hand corner. Is that your signature? Ms. Ford, is everything on that document still true and correct today? Okay. Ms. Ford, the court is going to find that you're indigent. Based on the finding of indigency, the fine of $250 plus court costs of $277, which comes to a total of $427, excuse me, $527, will be converted to 42 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. And the attorney's fees of $350 will be waived, which means you will not have to pay it. And that's pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. The $15 reimbursement fee will be waived, which means you would not have to pay that. And that's pursuant to Article 102.018 of the Texas Code of Criminal Procedure. Probation fee of $60 in this case will be reduced to the statutory minimum of $25 a month. And you will be required to pay your analysis fee of $15 a month. So your total monthly installments in this case is $44 a month. Will you be able to pay the $44 a month? Okay. Now, Ms. Ford, you will also be required to perform 30 hours of community service. This 30 hours is in addition to the 42 hours that was converted from the fine and court costs. So it comes to a total of 72 hours of community service. Do you understand that? Okay. Now, do you understand the state's offer? Do you, as well as the court's adjustments that have been made? Do you think it's fair and just? And do you accept it? Okay, Ms. Ford, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Ford, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Okay? And the non-disclosure basically means that your record will be sealed to the general public. All right? Okay, just have a seat and wait for your name to be called. And Mr. Grove, is this your only case?
Yes, sir.
Okay,
Thank you.
you'll be free to go and you have a blessed day.
Good one. Court is back in session and calls number 25 CCCR 0298 case of South State of Texas versus Holly D. Perky. Ms. Perky, you was previously sworn in, is that correct? And Mr. Lawrence, you waived the record in Ms. Perky's case, is that correct?
Yes, Your Honor.
And Ms. Perky previously really entered a plea of no contest to the charge of driving while intoxicated, second, which allegedly occurred on or about April 21st of 2024. Ms. Perky acknowledged that State's Exhibit number 1, the misdemeanor plea admonishment, she acknowledged that her initials were on the line on page 2 of that document that was titled nolo contendere, which means no contest. And she also acknowledged the signature on page 3. She also acknowledged
that on the next document, which was the trial court certification of defendant's right of appeal, that she, that was her signature on that document. She also acknowledged that her signature was on the discovery certification. And she also acknowledged that prior to signing and initialing those documents, that her attorney, Mr. Lawrence, went over those documents with her, and she understood everything that Mr. Lawrence went over. And that her initials and signature was freely and voluntarily given. She also acknowledged that she was satisfied with the services of Mr. Lawrence. And Mr. Lawrence acknowledged that there was no evidence that Ms. Perky is currently mentally incompetent to stand trial. She also acknowledged that she is a citizen of the United States. Yes, Mr. Lawrence?
All right, there was one thing, she didn't completely understand about the plea arrangement that, was tendered by the, prosecutor to us. There's restitution listed of $4,850. And, she states that all she did was run into a wooden fence.
Okay, now,
And-
Mr. Lawrence.
I'm just trying to,
Okay,
this is what she didn't understand, why that was in this order whenever insurance had already covered. the fee.
it's not an order.
It's in excess of the insurance.
It should-
Okay, that's
This is
that's
in the
negotiations that you and the prosecutor should talk about. The court does not get involved in the negotiations, and
Mhm.
you should be aware of that. The negotiations that goes on between the prosecution and the defense, the court cannot get involved in that. So my question to you is this: the state has tendered an offer. Do you accept or reject that offer?
Now, let me ask Ms. Perky, do you accept the offer as is?
Yes.
She'll accept it as is.
Okay. So now, so the court is going to accept Ms. Perky's plea of no contest. The court will find that Ms. Perky is mentally competent to stand trial. The court also will find that the pleas and waivers that has been entered by Ms. Perky has been freely and voluntarily given. And the court will also find that there is sufficient evidence to find Ms. Perky guilty in this case. And State, could you please restate the offer?
Yes, Your Honor, it's 180 days probated over 2 years. Fine is to be waived. There's $4,850 in restitution.
You said 4,000,
850.
850,
Yes, Your Honor.
850?
Yes, Your Honor.
Okay,
Payable to Gary Foster,
Gary Foster,
50 hours community service,
okay,
DWI second standard conditions of probation,
so there's an interlock.
and then the intervention. And defense counsel did confirm the date for her to turn herself in for the 72 hours.
And what's that date?
Friday, June 27th, 2025, at or before 6 p.m.
Friday, June 27th,
27th. Yes, Your Honor.
2025. At or before 6 p.m.
Your Honor, I assume the credit for time served does not go against
The
the,
2 days
the-
credit on the paperwork goes for support costs because the fine is waived.
Yeah.
It doesn't go to restitution.
Right.
okay.
Okay, so that's $100. Zero. What's the court cost? 392. And that's Oh. Let's see. Okay. Ms. Perky, the state is offering that you serve 180 days in jail, but this 180 days will be probated for 2 years. So you'll be on probation for 2 years. During the 2-year probation, you will not be required to pay a fine, standard fine. Oh, I got 2 days credit. And I need to, hold on a minute. I need to take that $200 off of that. Okay. Okay, now, Ms. Perky, the state is offering that you serve 180 days in Jefferson County Jail. That 180 days will be probated for a period of 2 years. During the 2-year probationary period, you will not be required to pay a fine. You will be required to pay a DWI conviction fine of $100. You'll be required to pay a probation fee, excuse me, a court cost of $391, $92, but you get the 2 days credit. So the probation, so the court cost, instead of being $392, it would be $192. Do you understand that? And you will also be required to pay court costs, not court costs, you'll be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, a reimbursement fee of $15. You'll be required to pay restitution in the amount of $4,850 to Gary Foster, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. Now, your total monthly installments, that is the total amount that you're required to pay each month is $318 a month. Are you able to pay the $318 a month? Okay, let's do this. Okay, so let's see. Give me her, Jeff's affidavit and just, okay. Okay. Miss Perky, I have before me a document that is titled misdemeanor plea admonishment. This document is, excuse me, that's titled Jefferson County Affidavit of Injuries. I'm going to hand this document to your attorney, and he's going to hand this document to you for you to review. Ms. Perky, do you recognize that document?
I do.
And on the back of the page 1, there's a signature in the top left-hand corner. Above the line that is titled defender signature. Is that your signature?
It is.
Okay. Now, Ms. Perky, is everything on that document still true and correct today?
I believe so. Yes. Well, this is school. But I'm gonna be in school during the summer.
Well, your expenses for the child expenses, that's a little low. Your total child expenses. Huh?
So our budget's are pretty. Food, this is like how much it costs. And it obviously just fluctuates.
Yeah, that fluctuates. She's saying that the total child expenses fluctuates,
Okay.
from month to month, Your Honor.
And
Okay.
the 850 income, that's during school, but I will have that in the summer.
Okay.
And you don't have any rent?
No.
Okay. This means the children have quality.
My oldest is 11.
Huh?
My oldest is 11.
Your oldest child is 11. Uh-huh.
You know,
Uh-huh. I understand now.
and this is
Okay. Let me see that. Okay. Okay, Miss Perky. The court is gonna find that you're indigent. And let's see. And that's pursuant to Article 42.15. On Texas Code of Criminal Procedure. So a state is offering that you serve 180 days probated for a period of 2 years, so you won't have to serve the 180 days in jail. You'll be on probation for 2 years. During the 2-year period, you will not be required to pay a fine. And that would be 2 days credit that is going toward your court costs, which is instead of being $392, it'll be $192. That $192 will be converted to 15 hours of community service. So you'll perform 15 hours of community service. The attorney's fees of $350 would be waived. You would not have to pay that pursuant to Article 26.05 G-11. The reimbursement fee of $15 will be waived. You will not have to pay that pursuant to Article 102.018 of Texas Code of Criminal Procedure. You will be required to pay the $100 reimbursement, the $100 DWI conviction fine or fee. You will not be required to pay the probation fees of $60 a month. That'll be waived pursuant to Article 42A.652, because the court is finding it will cause you to have a significant financial hardship. You will be required to pay the urinalysis fee of $360. And you will be required to pay restitution in the amount of $4,850. Cannot waive that. And so therefore, your total monthly installments, that is the total amount that you'll be required to pay, in this case is $230 a month. Okay?
Your Honor, may I make a statement in regards to the payments? I've spoken with probation and defense should be aware as well, and the state is aware that if for any reason the restitution becomes a burden, we are willing to continue the probation, so we're not gonna revoke her on that alone.
Yeah, okay. All right.
Yeah.
Ne-
What was converted? How many hours were converted?
Oh. It was 15 hours
Okay.
of community service. That's what you're talking about?
Yeah.
Yeah. Okay. And you will also be required to perform 50 hours of community service. So a total of 65 hours of community service. Do you understand that?
Yes, sir.
You'll also be required to install an interlock device on any vehicle that you own and operate. Attend and complete a DWI intervention class. Have an alcohol assessment. adhere to the other standard terms and conditions of probation, and you're also required to pay Jefferson County DWI. I don't know, is there an intervention fee? I know,
Not quite aware.
okay, if there is an intervention fee, I know on the DWI education fee, it's $125 on the day of the plea. Should that be a further evaluation as?
I said, I want to say they parallel each other, but probation should be.
Yeah, is there be a DWI intervention fee of $125? Should a further evaluation be needed, you'll be required to pay an additional $50. Do you understand that? All right, now, Ms. Perky, do you understand the state's offer and the adjustments that court have made? And do you think that it's fair and just? Do you accept it?
Yeah.
Okay, I'll follow the plea bargaining agreements that you have entered into with the state. Ms. Perky, just have a seat and wait for your name to be called.
Okay, I do have one question. Am I eligible for occupational license for school and all this?
You can talk to your attorney about that.
Oh.
Yeah. All right,
I have one point of curiosity, Your Honor. If at any point she became unable to pay, this restitution amount is what's bothering me. But if at any point she became unable to pay the amounts you just assessed, would that be a ground for revocation?
Your Honor, may I reiterate what I just said?
you can, but I mean, obviously, you can read the code and it'll give you some guidance. The code of criminal procedure gives you some guidance as to what, if that possibility cannot come up. The judge cannot give you in advance a judgment of something that may happen in the future. Okay, so I mean, you can read the code and there are motions and things that can be filed.
Sure.
So you can give guidance to yourself as well as your client. All right,
Due to the way it all happened, this restitution piece sounds like a civil matter instead of criminal matter to me,
but I mean, now,
that's
Mr. Lawrence, if you know, if you do not want to, if you want to reject the offer, y'all can do that. And then, I mean, you could accept or reject the offer. That's,
No, I assume Ms. Perky will agree to the offer.
yeah, Ms. Perkins sitting right there. I mean, she
Yes.
said she would follow it, but I mean, just coming back and rehash, going over the order again, it's not, that's an offer that's been accepted. If you're gonna accept it, fine. If you don't accept it, that's fine too. Then we'll go to the next step.
Did
but
you accept the offer?
She said she did accept the offer.
Okay.
Okay. I did? Oh,
The judge is not going to.
okay. This is, no stretching.
Yeah, I was thinking for a long time.
This is cause number 25 CCCR 0204. Case of style of state of Texas versus Kanisha Naomi Tyson. How are you doing, Ms. Tyson?
Good, how are you?
I'm doing fine. Thanks for asking. Ms. Tyson, you're representing your case by your attorney, Attorney Jack Lawrence. Mr. Lawrence, what is your announcement in Ms. Tyson's case?
From what I understand, Your Honor, she is rejecting the plea offer.
Okay.
And I would also, if she wants to try this case under the circumstances, I would also request to be allowed to withdraw.
You gonna withdraw because she wants to trial?
Well, no, not just simply that.
Well, I mean, let's do
The
this.
circumstances.
The
of
court
case.
does not have a motion to withdraw before.
No, I've just now, she just
So,
now told me she wants to, she does not want to accept the plea offer.
oh, that's fine. So we'll just set it on the trial docket.
Can I say something?
Well, you probably need to talk to your attorney first before you say something that might incriminate you,
It won't.
okay? You can just run it, but you could mention it to your attorney and see what he advises, okay? I'll give you a chance to do that. You can talk to your attorney. You can just, you can go and just talk to your attorney and you can come back up.
Over here and talk.
I was trying to request to get time to get another attorney.
So you want to hire an attorney?
Yes.
Oh, you still can do that, but until that happens, he's still your attorney, a
Okay.
record.
So what do I do?
You, okay, when you say, what do you do? The case is gonna be reset,
Okay.
okay? And we'll keep it on the announcement docket. And in the meantime, you can hire any attorney of your choosing,
Okay.
okay?
Mhm.
All right, so let's reset the case, keep it on the announcement docket. Okay, this case will be reset to June 25th of 2025. Mr. Lawrence and Ms. Tyson, you can get your recess. Once you get your recess, you're free to go. And you have a blessed day.
Thank you.
You're welcome. She has to get a reset. Okay, this is cause number 25 CCCR 0174, case of style of the state of Texas versus Tremaine Richardson. And Mr. Richardson, you're represented by your attorney, Attorney John Macy, who is appearing via Zoom. Mr. Macy, how are you doing?
I'm fine, Your Honor.
And Mr. Macy, what is your announcement in Mr. Richardson's case?
Your Honor, I've received and reviewed all the documentary discovery. However, I have not received any video evidence that exists. I requested it late, and so I haven't received it yet. So I haven't reviewed it yet. So I need to
Okay.
read that.
Okay, give us a reset date. Okay, this case will be reset to June 25th. Give your attorney an opportunity to get the video evidence and review it. Mr. Richardson, you're gonna get your reset here in court. Once you get your reset, you'll be free to go. And you have a blessed day. You're welcome. And Mr. Macy, this your only case. You're free to go.
Yes, Your Honor.
And you have a blessed day. Your reset will be sent to you.
Thank you, Judge.
Okay, you're welcome. Jefferson County Court at law number 2, back in session. The court is in session in cause number 25 CCCR 0236. Case of style, the state of Texas versus Herbert August Smith. Mr. Smith, is that your full name?
Yes, sir.
Mr. Smith, would you please raise your right hand? Mr. Smith, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Smith, you may put your hand down. How are you doing, Mr. Smith? That's good. Mr. Smith, you're represented in your case by your attorney, Attorney Todd LeBlanc. Attorney LeBlanc, how are you doing?
Doing good, Judge.
And Mr. LeBlanc, do you waive a record in Mr. Smith's case?
We do, Your Honor.
Mr. Smith, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Herbert August Smith, on or about April 14 of 2024, while you were operating a motor vehicle in Jefferson County, Texas, that you committed to Class A misdemeanor offense of driving while intoxicated, an alcohol concentration level of 0.15 or more. Mr. Smith, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Smith, how do you plead? Guilty, not guilty, or no contest?
No conflict.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Smith, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials on a line next to boxes checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification to Defendant's Right of Appeal, do you recognize this document?
Yeah.
Is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up the right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
Now, Mr. Smith, before you signed and initialed all of these documents that I've just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Smith, are you a citizen of the United States?
Yes, sir.
CO for state one.
Any objections?
I have no objection.
No objections. State's Exhibit Number 1 will be admitted. Mr. LeBlanc, you've advised in counsel, Mr. Smith, is there any evidence that he is currently mentally incompetent to stand trial?
None of them were of you.
Mr. Smith, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Smith, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement in this case is to one year probated over 2 years with $8,000 fine, 100 hours community service, the installation and maintaining of an airlock device, DWI steering conditions of probation, as well as DWI intervention.
Mr. LeBlanc, were you appointed?
Yeah.
What's the court cost? Mr. Smith, the state is offering that you serve 365 days, which is a year in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 2 years. During the 2-year probationary period, you'll be required to pay a fine of $1,000 plus court costs of $377. You'll be required to pay a DWI conviction fine fee of $100. You will also be required to pay a probation fee of $6 a month. You're not fee of $15 a month. Reimbursement fee of $15. You'll also be required to reimburse Jefferson County Court appointed attorney's fees of $350. You'll be required to pay Jefferson County DWI initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $158 a month. Will you be able to pay the $158 each month?
Yes, sir.
You'll also be required to perform $100 of community service, install the interlock device on any vehicle that you're on operate, attend and complete a DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of DWI probation. Mr. Smith, do you understand? Do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Smith, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Smith, this will conclude your case. Please stand at the end of that table, or just have a seat and stand next to the bailiff and follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day. And Mr. LeBlanc, you're free to go as well, and you have a blessed day.
Thank you.
You're welcome. Ray Glaude, Radarian Glaude. You can put your hat on that counter right there. Jefferson County Court of Law number 2 is in session and calls number 25 CCCR 0284. Case is style of State of Texas versus Redarian Devon Glau. Mr. Glau, is that your full name?
Yes, sir.
Mr. Glau, would you please raise your right hand? Mr. Glau, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Glau, you may put your hand down. How are you doing, Mr. Glau? I'm doing fine, thanks for asking. Mr. Glau, you're represented in your case by your attorney Jennifer DeLodge. Mr. Lodge, how are you doing?
I'm doing good, Judge.
And Ms. DeLodge, do you waive a record in Mr. Glau's case?
Yes, Your Honor.
Mr. Glau, in cause number 25 CCCR 0284, I have before me information that was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Redarian Devon Glau, on or about December 11th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of fleeing police officer. Mr. Glau, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest. That's it's a Class B misdemeanor.
Oh,
And in order to erase, you gotta use it like you're writing, but you have to press that first button at the bottom.
getting used to it, Judge. So basically, the sheet that was gonna do the admonishments and the punishment range, yours was a Class B. I was thinking it was evading, but it was actually fleeing police officer. So Class B, just means that you could have been, had a punishment range of up to 180 days in jail or $2,000 fine. Okay.
Okay. Now, Mr. Glau, do you recognize this document? On page 2 of this same document, there are a set of initials on the line next to a box that's checked noli contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Sure.
On the next document that's titled trial court certification or defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand the statement?
Yes, sir.
Second box is checked, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes.
Mr. Glau, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Glau, are you a citizen of the United States? State,
Stay over stage one.
any objections? No objections. State's exhibit number 1 will be admitted. Mr. Lodge, you've advised and counseled Mr. Glau. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Glau, your attorney, Mr. Lodge has advised and counseled you. Are you satisfied with her representation? Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Glau, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
The agreement in this case is to 1 year deferred probation with a $250 fine and 40 hours community service.
I say 40 hours service. And Mr. Lodge, were you appointed?
Yes, Your Honor.
What's the court cost?
$330.
Mr. Glaude,
Yes, Your Honor.
the state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You will be required to pay a fine of $250, pay court costs of $330. You'll be required to pay a probation fee of $60 a month, university fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $176 a month. Will you be able to pay the $176 each month?
Yes, sir.
You will also be required to perform 40 hours of community service and adhere to the other standard terms and conditions of this probation. Mr. Glaude, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? Do you accept the state's offer?
Yes, sir.
Mr. Glaude, I'll follow the people in agreement that you have entered into with the state. Mr. Glaude, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure, which means that your record will be sealed to the general public. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Mr. Glaude, you will stand next to the bailiff, follow her directions. Once you finish following her directions, you will be free to go and you have a blessed day.
You as well.
Thank you. The bailiff right there. Mandy Antley. Miss Antley, your full name is Mandy Antley. How are you doing, Miss Antley? That's good. Miss Antley, you're represented in your case by your attorney, Attorney Jennifer DeLodge. Mr. Lodge, what's your announcement in Miss Antley's case?
Judge, I'm gonna request a reset for more time to view, the media discovery, and potentially a trial date after that. At this time, we are not accepting any plea offers from the state.
Well, okay, give us a reset date. Okay, this case will be reset to June 25th, 2025. Miss Antley, you're gonna get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day. And Miss July, this is your last case. You're free to go as well and you have a blessed day.
Thank you, Judge.
You're welcome.
Blessed days.
All right, thank you.
Today is the day, isn't it?
Have it answered for negative comments.
Leslie Hill? This is cause number 25 CCCR 0268. Case is style of state of Texas versus Leslie Aura Hill. Ms. Hill, is that your full name? How are you doing, Ms. Hill? That's good. Now, Ms. Hill, you're represented in your case by your attorney, Attorney Ryan Matuska. Mr. Matuska, how are you doing?
Morning, Your Honor.
Good morning. Mr. Matuska, what is your announcement in Ms. Hill's case?
Your Honor, I think we're gonna reach an agreement, but I believe, Mr. Hubel needs one more thing.
That's correct, Your Honor. State is making efforts to contact the complainant with us and find out about restitution.
Okay. Give us a reset date on Ms. Hill. Would the standard reset be sufficient? for
Yes,
you
Your
to
Honor.
Get the information, okay.
We expect to hear from the complainant witness soon, and if we do not, we'll be moving forward.
Okay.
Okay, Mr. Hill.
Yeah, page 5, Leslie R. Hill,
25th.
June 25th. Okay, Mr. Matuska, Ms. Hill's case will be reset to June 25th at 9 a.m. Ms. Hill, you can get a copy of your reset from our coordinator. Once you get a copy of your reset, you're free to go and you have a blessed day. And Mr. Matuska, you're free to go as well and you have a blessed day.
Yeah, I have one more case.
Yes, do we have an update on that?
Right, got 2 drug court probably about 20 minutes ago, so if they had a hearing instead, so they're probably in the midst of it right now.
There is a hearing that Hammond is having.
What did you say?
He's talking about Hammond, right?
Hammond, yes.
He's having, a hearing.
So they're probably right in the middle of it, because he just got to the report about 20 minutes ago.
Now, we have a jail run on tomorrow. If, depending on what the outcome of the hearing. If that case is disposed of tomorrow, today, by way of the hearing, we can set these cases for tomorrow.
Not all the pins and towns may not find until late, but we do have a docket on Friday as well.
Well, it's gonna either be tomorrow, today, tomorrow or Friday.
Yes, sir.
If the case is resolved.
Right, if they're resolved, right. If not, if they're not resolved, they're gonna reset it to another day. We have to reset it on that day.
Okay, I'll be here.
Okay, we'll let you know.
Take care.
Okay. This will conclude the calling of the court's announcement docket and the motion to revoke probation docket, both dockets on today's date of May 7th, 2025 in County Court at Law number 2. Judge Terrence Holmes presiding. Everyone, please have a blessed day. You're welcome. And prosecutors, you are excused.